crucial for smooth functioning of any business and economy, especially in India. The current legal landscape is ever changing, and it is imperative for professionals in the field of keep up to date with the latest development and regulatory changes. If you ask me what is the main struggle of professional, that after studying, they can't sit idle, they have to update continuously, and updation will come on the basis of these changes which are taking place. They should know, and they should be very clear that what is the impact, what they have studied, and what they were practicing earlier. So in this webinar, our subject expert will discuss present and update and its context, compare it with the old law, analyze the implication of new law. So in the process, when they will discuss, there are some queries they will tell you, and in the process, even if you think some more questions are unanswered or some more new issues as is emerge, you can ask from us. From this webinar, participant will get benefit like interactive learning and comprehensive updates, expert insight for better understanding of the new law, issue resolution through Q&A, and valuable resources in CP Connect newsletter, which we are sharing with all participants every month, which we are coming out. Our panel of experts comprises of regulatory experts who will share their insight and experience on the latest legal updates and regulatory changes in this area of law. They will be also discuss the impact of these changes on our business and economy. And I extend a hearty welcome to the galaxy of speakers for today. First, we have Anjali Agrawal, Partner Head Capital Market Services, Corporate Professional. Then we have Mr. Manoj Kumar, Partner Head M&A and Transaction, Corporate Professional. Mr. Nitesh Ratwal, Associate Partner Corporate Affairs and Compliance, Corporate Professional. Ms. Priyanshi Mittal, Associate Corporate Professional on Corporate Affairs and Compliances, and Nikita Vijay, Senior Associate, Securities Law and Corporate Litigation. Friends, we are sure that this type of webinar will definitely give valuable input and platform for learning and discussion. And we hope that it will help you all to gain the better understanding of the recent regulatory and legal updates in the field of company securities and insolvency law. All the participants of this webinar will receive our newsletter CP Connect, which covers all regulatory updates, important case law, articles, compliance calendar for the month of August, and CP Think Tank, in which you will get the update regarding our new publication and all our new webinar. Friends, the purpose of this webinar, which I have told you earlier also, is very important. Whatever in the 1 month from first Friday of the last month to this Friday of this month, whatever new law, new changes from SEBI side, from corporate law side, Ministry of Corporate Affairs side, RBI, FEMA side, and the insolvency side, whether it's a case law, whether it's a legal updation, legal changes, we all discuss. And the discussion structure is also very clear, that we want to discuss that what is this law, what are the difference between last and this, and what will be the impact. So this type of thing we are creating and we are bringing out. In today's webinar, if you see, there are so many changes like NCA notified SBA rules in LLP. That is one part of the is part for company law. Then in SEBI expand the scope of minimum public shareholding requirement in InvIT, which was earlier not very clear. That they have clarified now. Procedural framework of unclaimed amount lying with the writ and InvIT in manner of claiming such amount by the unit holders on the IPF front, and same thing, unclaimed amount lying with the entities having listed non-convertible securities and how to claim this. So till now, the IPF system is there for security, but these things were not there. So they are bringing out slowly. Then key decision for SEBI's board meeting, which is on 25th. SEBI had their own meeting, and in this they have changed the rules for social stock exchange. They have dropped out the facilitation of small and medium rate, and then the protection and interest of alternative investment fund AIF that they have brought out. Now, other than this, there is one consultative paper which has come out by the Special Situation Fund, a subcategory of Category 1 alternative investment funds necessary to facilitate Special Situation Fund to acquire stressed loan in terms of Reserve Bank of India, Transfer Loan Exposure Direction 2021. That also has come, so that we will discuss because these new concept note which are coming by the regulator, it's the best and right time to raise our issues, raise practical issues when the law is becoming the permanent feature. That time when we face problem, it is better we should do. So our effort is that we should create this type of structure or this type of discussion forum that people should come and do and raise their issue. So when the government is making law, they can modify as per the practical issues. Then we have a consultative paper on providing flexibility in provision related to trading plan under SEBI PIT regulation. That briefly we'll discuss, but we are having, because this is a very important topic. So next Friday, we are having this program, a detailed program, consultation paper on providing flexibility in provision realizing the trading plan under insider trading. So SEBI, 3 officers from SEBI and 2 officers from stock exchanges, BSE and NSE, and the expert from the market companies and practitioner, they all will discuss this issue, the complete aspects of trading plan, what SEBI is proposing, what are the issues in this, and how this can impact everybody. And even if something is missing out, then after the outcome of this webinar, we will submit it to SEBI that these are the queries. Is still not clear through even the consultative paper is out or proposed law is out. So it is better that when they're making a final law, they modify it. So that we will discuss on Friday, next Friday on 8th, and request all you to join this program. So I will stop here. And first, I will request our learned speaker, Nikita. She will discuss about the consultative paper on trading plan. And Nikita, we have to just discuss very briefly so people should understand. And next Friday, we will detailed discussion will take place. So over to you, Nikita.
Thank you so much, sir. First of all, so basically, SEBI has come up with a consultation paper on providing flexibility in provisions relating to trading plans under the SEBI PIT regulation. So the intent for coming for this providing of flexibility in the provisions of trading plan was majorly because uh, there were not much trading plans submitted by the designated person by the insiders of the listed companies, which showed that it has not been a very attractive option for the KMPs and for the insiders who are in the listed companies to have this to avail this option of trading plan. So somehow this option was becoming a redundant. So SEBI felt a need for providing certain flexibility so that the insiders and the designated person can avail this option of trading plan, and it can be executed in the manner that that should not hamper the market integrity and should also be in the benefit of the designated person and insiders. So, if I just explain you in brief, so there were certain constraint in the current provisions of trading plans, allowing insiders to trade in a compliant manner while perpetually in possession of UPSI. So the major the major applicability of the trading plan was basically the intent was for the senior management people who are perpetually in the possession of UPSI. So, for example, the managing director, the promoters. So these are the people who are almost every day they are have one on the another UPSI in their knowledge. So they wanted to through this trading plan, they wanted to have them to have an option to trade in the shares of their listed companies, and but current provisions were very restrictive in nature. Next slide, please. So, the working group submitted its recommendation to SEBI. First of all, I would also like to inform you that one of our partners, Ms. Mohini Vaishnav, was also part of this working group, who also participated in giving these recommendations. So the recommendations included, the first recommendation was a cool-off period reduction. So currently there is a cool-off period of 6 months, which says that for a period of 6 months, you have to submit and formulate your trading plan for before the implementation. There's a 6 months gap from the formulation and the implementation of trading plan. So first recommendation was to reduce this cool-off period to 4 months. Second amendment is with respect to the minimum coverage period reduction. So earlier, the minimum coverage period reduction was 12 months. So 6 months first you have to wait for the implementation. Then it was that for the 12 months you have to cover your trades, whatever your trading plans are. So they were facing. It showed that they were facing difficulty in covering such a long period and planning their future trade for 12 months. So they have reduced it to 2 months. So effectively 4 months cool off period and 2 months of the implementation. The total period has come down to 6 months from 18 months. Third is elimination of blackout period. Earlier there was a provision of a blackout period. There was a period when after the announcement, before the 20th day of the announcement of the financial, and after it become publicly available for 2 more days, they cannot trade in the share. The designated persons cannot trade in the shares of the company. So effectively, there was a very less time available for the designated person to actually trade in the company. So the applicability of blackout period under the trading plan was posing significant challenges for those designated periods to have the available time period for formulating such trading plans. Next, please. So fourth is a very interesting amendment that they have come up with. They have so earlier only the number of shares, the value, the number of shares they want to trade, the value of shares, uh, all these things were required to be part of the trading plan what they submitted to the compliance officer. Now the new requirement has introduced that they can set a price limit for plus minus 20% for buy and sell trades in the trading plans. So basically, within this limit, for example, if you want to trade 100 share, you can actually give a price range. For example, from the prevailing market price. So if the prevailing market price at the time of formulation of plan was, for example, 100 rupees, so you can give a price limit of 120 or 80 to 100, 100 to 120 or 80 to 100. But they have also said that trades outside this is basically depending upon your risk appetite. But outside these limits, it is mentioned in the consultation paper that you cannot execute the trades outside these limits. Next is contra trade next is contra trade restriction. So basically, contra trade restrictions are basically that if you buy a share in a listed company, you cannot sell that within these 6 months, because it is generally said that for this time period of 6 months, the UPSI, which if there is any UPSI in the company, that will be generally made available in the public within a period of 6 months. But earlier, this exemption was provided in the trading plan because the trading plan period was from total was 18 months. So earlier this exemption was provided because it was understood that the UPSI might not have gone this much long and designated personnel could not have the advantage of in within this long period. So, but now that the period has been minimized from 6 to 4 months, and the coverage is has been minimized from 12 to 2 months. So now they have said that the contra trade restriction should be applied in the trading plan also. The intent is also that if somebody is planning their trades, either they will plan to sell their holding, or either they will plan to invest in the shares of their listed company. So contra trade restriction should be applied. Next amendment was timeline for disclosure. So earlier, it was only mentioned that there should be a disclosure of trading plan to the stock exchange, but no timeline was given. Now, it has been said that within 2 days from the approval, the disclosure of trading plan should be made to the stock exchanges. Seventh is format for reporting TP details. So earlier there was no standardized reporting format. Now the working group has recommended that there should be a standardized reporting format standardized reporting format for the disclosure of these trading plans. Next, please. So the consultation also deliberates on the disclosure of personal details. It explores basically three alternatives, continuing with the full disclosure, whether all the personal details of the insiders will be disclosed along with the trading plan for informed decision and monitoring by the stock exchange, masking or protecting the insider privacy by concealing their personal details in the trading plan. So insiders make so basically what they have said that it is we can share this disclosure without the personal details because insiders make separate filings, one with personal details to the stock exchange, which is kept confidential, and one without the personal details made public. A unique identifier is suggested for reconciliation between these two filings. Next, please. So now SEBI seeks feedback and comments from the stakeholders on these proposed amendments for the trading plan framework by latest by December 15, 2023. With this consultation, it seems that SEBI has been proactively taking these changes so that a better framework could be framed for the benefit of the market and also for the designated person. As Sir said, we will be discussing. This is just a brief. We will be discussing all the nuances of this consultation paper in our next webinar. Thank you so much.
Thank you, Nikita. Thank you very much. No doubt, this trading plan will definitely give boost to the designated insiders because earlier they were supposed to give plan, but the plan was not flexible and you have to follow even if you are in loss. So now SEBI has come out more realistic plan and definitely it will be flexible for both. And the information which they are providing, it has a limit also. So in case the limit is crossing, then you can change the plan also. So it is a welcome move. Let's discuss. So many issues are there in this. So tomorrow, next webinar, we will discuss this part. We are not going in detail because this is the issue which has come. So we have taken the glimpses of this. Now, the new things has come in company law that SBO, that is for companies, now they have brought out for the LLP also. So significant beneficiary ownership concept, which was earlier for the company and then who are behind this company, now they have brought out them for LLP also. So in the LLP, we want to understand because in LLP, how to calculate 10% threshold, contribution concept, and how this LLP when 4 will submit non-compliance, what will happen, and the process of declaration, false declaration, register of maintenance, and what will happen before the changes, and how to maintain register of SBO, and what will happen in the existing regulatory. These all things they have tried to cover up. But what new issues has erupt and what are the compliance part pre and post? Over to you, Ritesh. You please explain each and every part.
Thank you, sir. Thank you. Uh, Hello.
Yeah.
Yeah, thank you, sir. Thank you. So, as we know that the last month MCA notified SBO rules in the LLP. So first we understand the what is actually all about.
Little bit louder, Ritesh. Little
Yeah.
bit louder.
Hello. Is it
Yeah.
audible? Yeah. So let's first understand what is SBO if one is not aware what is SBO under company law, because the whole rule has been actually imported from the company law. So we need to first understand what is all about SBO, what is beneficial interest. So from the governance and the transparency point of view, recognizing the beneficial interest plays a very important role, which ultimately enhance the business environment and fostering the improved corporate governance, not under the not for the companies but also for the various entities through which anybody does or run his business. The aim is to actually reveal the true decision maker and the interest holder associated with such entities, there which ensures their legitimacy, because if there are structures in a entity which is through which nobody can actually rely who is the real owner, then some can raise his concern, or some regulator has a different view, because if there are so many companies or corporates or LLP or partnership from any entity, even HUF trust, then there are good chances that there are some kind of concern in the governance structure of those business enterprises. So recently the MCA has taken some step towards this in the form of what you call it, advisory notes to all the companies who are registered under Companies Act, to actually disclose the beneficial owners if they have not done so since the notification of the rules in 2018. So taking a clue from that, and MCA now has extended the SBO provisions to the LLP. So this is the rules actually notified this year on November 9th of November 2023, but last year MCA issued a notification on 11th of February 2022, through which the provisions of section 90, which is the ultimate provisions, which are the parent provisions of that SBO of the Companies Act, were made applicable to the LLPs. Uh, to further achieve the same objective of identifying the SBO in the LLP. So Section 90 of the Companies Act tests the identification of an individual as a SBO of a company or LLP from now onwards. In a and a later a year later, MCA also amended the LLP rules by inserting Rule 22A, 22B to strengthen the mechanism for identifying the person having a SBO in LLP. So, what do you mean by SBO? If somebody don't aware of those Section 90 and the rules made there under Companies Act.
Nitesh, little
Yeah.
bit louder. थोड़ा सा loud बोलना है.
First we need to understand who is the SBO in LLP. So SBO is nothing but a person who is the beneficial owner, either acting alone or together, or through some corporate structure, or through through relative, or some partner, if they are having a stake of at least 10% of stake in a LLP, or a voting rights with respect to decision making. It is not the voting right which is connected generally to a shares, but voting rights in connection with the management rights. or 10% of the distributable profit if they have a stake, or if they have a say in distribution, if they have a stake in this profit distribution of at least 10%, or which have a right to exercise or actually exercising significant influence or control. If this threshold limit is triggered, then you are subjected to filing under the SBO. Then you need to check who is the SBO, which we in the next slides get into the intricacies involved, how to identify a SBO in LLP. So you need to have a you need to comply with the threshold limit of 10%. Shivam, next. So exercising rights or entitlement acting together. If an individual is acting through any person or through any trust and having a intent or purpose of exercising any rights or entitlement, or actually exercising control or significant influence over a reporting LLP, either pursuant to an agreement or even an understanding, whether formal or informal, then it will be, you will be deemed to be called as acting together. If I have a partner who we have a understanding, not a formal understanding, not a understanding which are expressed, which are actually in terms of agreement, even if it is a formal understanding with our own action, then they are deemed to be, we both are deemed to be in acting in concert, or acting together to control a LLP or any entity. Then such individuals shall be deemed to called as a acting together. Next. So there are various permutation combination through which we can analyze who whether there is a, whether you actually comply with the threshold limit or not. If you are directly owning in an entity, then you are not subjected to SBO rules. If you are owning some stake or a threshold limit stake, at least 10%, but through indirect route, then you are actually subjected to SBO filing. Then if you have both direct and indirect holding, then also you are subjected to SBO filing. So meaning thereby, if you have a direct holding and only have a direct stake in the LLP, then you are not required to actually you are not subjected to filing, or you are not subjected to filing or make any declaration under SBO rules of LLP. Next. So one need to understand exercising the rights and entitlement directly or indirectly. So exercising a right directly is very simple, that you have a stake in a entity in a LLP for the reason, then you are not subjected to any filing, because you himself is a, or herself is a direct owner of that LLP, or a direct stake, or having a direct stake, that you are not subjected to. So the indirect route is very important, and here we need to analyze what can be the what can be the route through which you indirectly have a stake in an LLP. So through body corporate, if you have if you if any body corporate in which you own that body corporate, and that body corporate having a substantial stake in that LLP, then it is an indirect route and you are subjected to filing. If you are owning some stake through HUF, through trust, or partnership, or LLP, or pooled investment vehicle, then it is a indirect route for you, and for that matter, you are need to check the threshold limit, and after checking the threshold limit, then you need to declare yourself as a SBO. Next. So the body corporate, how could be the structure of a body corporate through which you will have a stake in that LLP? Let's suppose Mr. A having a majority stake in Y Limited, and that Y Limited in turn having a 10% or more stake in X Limited, then Mr. A shall be a SBO and subjected to filing a declaration with the LLP and the LLP to the ROC. And if there are if there are partners, if they and in a same structure, if there is a X Limited, Z Limited who is having a stake in Y Limited and Y Limited having a stake of X Limited, then we need to go to the ultimate holding company, that is Z Limited. Then we need to check who is actually holding the majority stake in that ultimate holding company. In this case, second case, A Limited is a majority stakeholder. But if you establish that A, B, and C also acting in concern, then all three will be a SBO for this purpose. Next. This is a trust route. So the trust route, because there are many corporate houses which uses a trust route to own a company or a LLP. So in this first case, a trust having a stake of more than 10% in X LLP, and in that trust, Mr. A is a trustee. So Mr. A become a SBO if that in case it is a discretionary and charitable trust or charitable trust. In the next example, there are trustee A and Mr. AA and Mr. BB and are the beneficiaries, and then in that second example, Mr. AA and all those both the beneficiaries will be the SBO in this example. Next. So how SBO will be determined where trustee is a body corporate? If a trustee is a body corporate, then we need to check who is the ultimate owner of that. Who is the ultimate owner of that? If you are not able to determine that who is the owner of that trust, then who will be the trustee of that trust will become a SBO for this purpose. Next. So there are routes. There are another route that is a partnership or a LLP, wherein the reporting LLP, where the partnership or a LLP who is actually a partner in that reporting LLP. So if your part if your in your LLP, if one of the partner is actually a partnership or another LLP, then every partner of that partnership or LLP, then every partner of your partner will become a SBO for this purpose. In case a, in case one of the partner is a body corporate, then we need to check who is owning a majority stake in that body corporate partner. If that body corporate in itself is owned by another body corporate, then we need to see the ultimate holding company structure. If in that ultimate holding company structure, we need to see that who is actually owning the majority stake in ultimate holding company of that body corporate, who is a partner in our LLP, who is subjected to filing under SBO rules. Next. So there is also a pool investment vehicle like REITs and REITs and others. So if that vehicle is actually is a partner in your LLP who is subjected to SBO rules, then if that pooled investment vehicle is based on under a member state of FATF on money laundering and the regulator of the securities market in such member state, then we need to check who is actually a general partner, who is the investment manager, or who is a CEO of that investment manager of that investment vehicle. Then in that scenario, all these person, if either of them is there in that investment vehicle, either a general partner, investment manager, or CEO of that investment manager will become a SBO under these provisions. If your pooled investment vehicle is based out of a jurisdiction which is not FATF or is not a member partner of FATF, then the provisions in that case is the body corporate partner trust, as the case may be, shall apply. So in that case, you need to follow the earlier rules. Next. So significant influence is actually a definition which is also imported from the company law, which significant influence means which gives you power to participate directly or indirectly in the financial and operating policy decisions of that LLP, but who is not in control or joint control, because control in itself is also a subject to filing of SBO. So if you are not in control but having a significant influence, then you are also subjected to SBO. You are subjected to filing SBO because you are deemed to be you will be considered as SBO under the SBO rules. So in this case, wise a foreign investor holds 40% stake in X Limited, and X Limited has 3 subsidiaries: X Limited, XY Limited, XZ Limited, and Y exercising significant influence in these 3 X Limited, then Y will be a significant is deemed to have a significant influence in these subsidiaries, then Y is subjected to filing the declaration under SBO rules. Next. So there is also a concept of holding beneficial interest along with any other person. So as we already talked, if you are holding along with any other person, then there must be a with the common objective. You must have common intent to control that entity, and if it is established, then if it is established, or you actually agree, or you actually do not disagree, that you do not act not in accordance, or you do not act in concert, then you should be deemed to be persons who are acting in concert to control an entity, and in this case a LLP. So in the first case, there is that C Limited, it's not C Limited, CLLP. So if CLLP, we need to check who is owning that 10% threshold limit, that is B Limited, and B is controlled by ultimate holding company, that is A Limited, and under A Limited, X, Y, and Z actually in concert holding 33% stake each in A Limited, and in this case XYZ will become SBO for CLLP, not C Limited. In the next case also, it is also under the same line. Then A, B, C, who actually holds 100% stake in the step down companies, that is A, B, C, and in turn they are also holding 33% stake each in Z Limited, and Z Limited owning some 75% stake, which in turn owning X LLP. Then in that case also A, B, C will be a SBO for LLP X. Next. So there's also a concept of holding beneficial interest through any person. So here in this case, Mr. DD, it is basically a question. It is basically a concept that somebody act as per the instruction of somebody who is actually out of the picture in a general structure. If there is any person exists according if there is any person upon whose instruction Mr. or any partner acts in accordance with the direction given by that the third party, then that third party will become a SBO. So in this case, Mr. DD will be a SBO for CLLP. Next. So this is also one of the example through which any person act in accordance with the direction, because under any agreement here, the agreement is something like of loan agreement, and Mr. DD has actually Mr. X and Y actually holding a stake in ultimate holding company, that is A, and Mr. Z owning some other stake 33% in A Limited, and in turn A Limited holding stake in B Limited, and B Limited holding 10% or more stake in C LLP. And the situation is like that, the XYZ are the shareholders in the company, but they have borrowed the fund put by them in A Limited, which is taken from Mr. DD under a loan agreement, and dividend received from Mr. A Limited is being paid to Mr. DD. So meaning thereby Mr. DD have a stake in the profit distribution. If this is one of the criteria of SBO, if you have if through any agreement, if you have a stake, either as a contribution or either as a right towards distributable profits. In this case, a distributable profit, if you have a stake of 10% or more in distributable profit, then you also considered as a SBO. So in this case, Mr. DD will, because they have a stake in that whatever be the profit is distributed among the partners, if Mr. DD have a stake in CLLP, and if it is more than 10%, then Mr. DD will be a SBO under this structure. Next. So report, what is the actually, if somebody identifies that Mr. X or Mr. Y is a SBO, or they have complied with the minimum threshold limit, then what is the requirement? Then that requirement is that reporting LLP first need to identify if there exists any individual and who actually qualifies as an SBO, and have them declare their status using this band 1 form. If a partner other than individual holds at least 10% stake in the contribution or voting rights or right to receive distributor, as we discussed in the last example, the LLP must notify such partner that you are actually meeting the threshold limit. Then that LLP will notify to such partner using band 4 to obtain the necessary information. Next. Thereafter, SBO must file a declaration using band 1 to the reporting LLP within 90 days of the notification of this rule, and the last date will be February 7, 2024. That that SBO declaration must be filed with the ROC. And if there's any subsequent change in the SBO status or changes, further changes therein, then that also must be declared and filed with the ROC within 30 days of such occurrence. Next. So if an individual becomes an SBO or undergoes any change in their status before February 7, then the deemed date for change will be the February 7, and the 30 days filing period will be calculated accordingly. Next. So what to do when you declare a dividend from SBO? Then that LLP have to file that declaration in band 2 with the ROC within 30 days of receiving the declaration. And then LLP are required to, once the filing is done and all thing is done, then you also need to keep a register of SBO in form that is LLP band 3. So this is the compliance which any LLP has to comply with if they are subjected to filing under this SBO rules. Next. So there's also exemption list under the SBO rules. It is actually different from the company SBO rules because there are more exemption in case of company as compared to LLP rules, LLP SBO rules. Here, the central government is actually exempted from filing any kind of declaration or any reporting LLP or body corporate or any other entity which is actually owned or controlled by any government or part by any government, and InvITs and REITs are also not subjected to filing, or any investment vehicle which is actually regulated by RBI or IRDA or PFRDA, Pension Fund Development Regulatory Authority. If these are the investment vehicles registered, regulated by these financial these what you call it regulator, these financial regulator, then you are exempted from this LNP SBO rules. So that is from my side. Hello.
Nitesh,
Yeah, sir. That is
thank you
from my
very
side.
much. There are some, I have some queries relating to SPO.
Yes, sir. Tell me.
So just tell me, how does an LLP identify an individual who qualifies SBO when the ownership structure involve multiple entities or trusts?
So if if the trust is involved, then we need to check whether it's a discretionary trust, whether it's a beneficiary trust, if that is a, if in case, or a charitable trust. If the trust is of a nature of a discretionary or charitable trust, then a trustee will become a SBO. But in case if it is a private trust which is actually for the benefit for identified persons, then such beneficiaries will become SBO for the purpose of this rule. And we have actually covered one example in our presentation with respect to trust.
Okay.
Yeah.
What are the consequences if the individual who should declare as SBO fails to do so within the stipulated 90 days time?
So, this is the timeline which one needs to comply with. If they still do not comply with, or if they have failed to comply with, then they can do it. There's no such restriction that they cannot do it. But yes, there will be a penalty. There will be a penalty clause if you declare yourself or fail to file a declaration. If somebody actually do not declare or at any time, or do not declare himself as a SBO, then it is the responsibility of that LLP. Then they need to identify.
Okay. If an LLP has doubt or conflicting information regarding an individual's SBO status, what recourse or procedure can they follow to resolve such issue?
So in that case, they can actually they can demand some declaration or information that is prescribed in the format. Then if in that also that SBO do not provide such information, then they or still there is a confusion, then they take a declaration from those individuals that they do not have any stake, or they do not act in concert with other partners. Then they will take them these declaration on record for the purpose that in future, if somebody comes up that he or she is a SBO, then you have a document to establish your case.
Okay. If an individual acquires SBO status after the February 7th deadline, what would be the procedure and timeline for declaration of and filing?
So that is a timeline through which you will not be considered as you are a default or late filing. If you still do not comply within that timeline, then you will have a time, then you can file it, but with a penalty. You can still comply with the rule, but with the penalty provisions comes into picture.
Okay. And what are the penalties and consequences for LLP that fails to file? When to with registrar with the stipulated 30 days time?
So there's a penalty prescribed under section 90. So that will be applicable.
Okay. And how to clarify the calculation of 10% threshold?
So one needs to first check whether the different partners who are if they are individual, then they are out of it. They do not require to file anything because they consider themselves as a SBO or consider as a only the beneficiaries. So they do not actually fall under this SBO rules. Yes, if there is a body corporate, then we need to check the body corporate, that who is owning that body corporate. If that body corporate is a partner in my LLP.
Okay. And definition of contribution?
So definition of contribution is very simple. It is go by what is mentioned in the LLP agreement.
Okay. So I think thank you very much, Nitesh,
Yes,
for
sir.
giving this detailed one. Now come to the Priyanshi. Priyanshi, you have to cover writ and in-writ related amendments which has taken place. And these are the two in place of doing the debt market and equity market, people are going for alternative investment as a investment vehicle. So these are shortly will be very popular. The way they are coming out, the way regulator is also putting efforts, and some issues are there for this. So they have rectified it now. So now over to you, Priyanshi, to please tell us what are the changes in written and in bit.
Thank you, sir. Hope I'm audible.
Yeah, little bit, just be little loud.
Sure, sir. Good evening, everyone. So, SEBI has released a circular on October 31st, 2023, relating to the manner of achieving minimum public unit holding requirement in infrastructure investment trust, that is in REITs. Before going through the provisions of the circular, let us just have a quick overview of how these InvITs work. So InvITs are SEBI registered special purpose investment vehicles who pool money from the investors, and they primarily invest in the infrastructure projects like roads, bridges, highways, and the income that is generated primarily from the toll collection. So they distribute that income in the form of distribution to the unit holders. They are similar to how REITs work. Now, going through the referring to the circular back, so regulation 14 of InvIT regulations already prescribe the minimum public unit holding requirement. Shivam, if you can move to the next slide. So, regulation 14 of InvIT regulations prescribe the minimum public unit holding requirement for REITs depending upon the size of the InvIT. So, where So now, and the master circular dated July 6th, 2023, which was issued for InvITs, has laid down certain methods, nine methods for achieving such minimum public unit holding requirement. Now, this circular has added one more method for privately placed InvITs to achieve their minimum public unit holding requirement. That method is by way of issuance of units through preferential allotment. And when such InvIT will issue the units through preferential allotment, so the units that will be issued to public shall only be considered for the purpose of achieving this requirement. So this is a new method that has been added. There's also one more amendment through this circular, the already prescribed method 7 in the master circular. So it related to achieving the public unit holding requirement through sale of units by sponsors, investment managers, or their associates or related parties. And the main criteria for ascertaining the number of units that could be sold through that method was dependent on the average trading volume. Now, two provisos have been added in that method, which states that the average trading volume criteria shall not be applicable in case of privately placed entities. So these are the two basic amendments which have been introduced by way of this circular. Moving on to the next amendment, which relates to which leads to REITs and InvITs both. So SEBI has through this circular laid down a procedural framework for dealing with unclaimed amounts, that is distribution or interest lying with the REITs or InvITs, and the manner of claiming such amounts by the unit holders. So to give a brief background, REIT and InvIT regulations prescribe that not less than 90% of the net distributable cash flows of such REITs and InvITs shall be distributed by way of distribution to the unit holders. Now, when and also this distribution is to be paid within 15 days of such declaration. Now, and this distribution shall be made at least on a half yearly basis. However, as practically we are seeing that most of the Indian REITs are declaring such distribution on quarterly basis. So when such REITs and InvITs declare the distribution, so we have observed that certain amounts have been left unclaimed or unpaid due to various reasons like lack of proper information, proper details on the of the unit holders available with such REITs and InvITs. So REIT and InvIT regulations already have a provision in the place which was introduced in February 2023, which provided that any amount which is left unclaimed or unpaid shall be transferred to SEBI Investor Protection and Education Fund in the manner as may be prescribed. However, no manner was such prescribed as of today, as of on the date of this circular. So SEBI has, by way of these circulars, each for REIT and InvIT respectively, has now laid down the manner. So briefly to go through the provisions of the circular. So the steps would be that as and when the distribution is declared, so within 15 days, REITs and InvITs have to pay that distribution to the unit holders. Where any amount is left unclaimed and unpaid during such 15 days, so such REIT and InvIT has to open a separate account to be referred, a separate escrow account to be called as unpaid distribution account, and deposit such unclaimed amount within 7 days from the expiry of such 15 days. Where any delay is caused, where such any amount is not so transferred within 7 days, so an interest at the rate of 12% per annum shall be leviable on such default period. After transfer of such amount to escrow account, any investor can file the claim. Now, any amount which remains in such unpaid distribution account for 7 years, then such amount is to be transferred to SEBI Investor Protection and Education Fund within 30 days of expiry of such 7 years. So these are the provisions for transferring such amount to unpaid distribution accounts. Now, there are other and as both these circulars for REIT and InvIT, they are applicable with effect from March 1st, 2024. So as a first time requirement, REIT and InvITs, all the unclaimed amount all the amount of distribution which remains unclaimed as on February 29, 2024 is to be transferred to an escrow account by within 7 days of the within 7 days from March 1st, 2024. So this is the one-time requirement when these circulars become applicable. There are certain other key actionables arising out of these circulars. First is the designation of nodal officer. So the REIT and InvIT managers have to designate either their director, chief financial officer, or company secretary or compliance officer as a nodal officer who will be the point of contacts for the investors and for SEBI, and will be the point of contact for processing of such claims. And the details of such nodal officer shall be also be displayed on their websites. Second is formulation of two policies. So one policy needs to be framed for the unit holders, which will detail out the manner of filing of such claim, the documents that need to be submitted along with such application, the timeline within which such claim will be processed, and other details, other relevant details. One second policy has to be an internal policy, which will be for the managers to underline how such claims will be processed and how the verifications of such claims will be done. The policy which is to be framed for the unit holders shall also be placed on the website of such REITs and InvITs. Next is remittance. So as and when the claim is received, so the managers will verify such claims, and within 30 days, they have to remit the amount due to such investors. If they want to call for any additional information, they may also communicate the need for such information to the unit holders, and the unit holders will be required to submit such additional information within 30 days of the such communication. So this is regarding the remittance. Next, there is all the details of the amount which is left unclaimed and unpaid, and the claims that have been received. So cumulative details need to be uploaded on the website of such REITs and InvITs, and a search facility needs to be provided to the unit holders where they can search whether any amount is owing to them is left unclaimed or unpaid. So the search facility also needs to be provided on the website. Next is so this after the search, the all the amounts that are unclaimed amounts that are transferred to the unpaid distribution accounts, they also need to be displayed on the website within 30 days of such transfer. So this is the detailed procedure which has been laid down in these circulars, which will help the unit holders to file for the claims of their unpaid amount, which the procedure was not there till date, so the claims could not be filed. But now the circulars have simplified the procedure. So that's it from my side.
So, so in your opinion, what is the future you think written in InvIT has will see in the future?
The REITs and InvITs have a very prominent future in India, I believe, since REITs and InvITs are already very popular in foreign countries like US and Singapore. It's a relatively new concept in India, but it has been growing at a very fast pace. More and more investors are now interested in investing in such REITs and InvITs, since they allow us to directly invest in real estate. Apart from REITs and InvITs, normal investors face it very difficult. It's very difficult for them to invest directly in the real estate sector of India. But REITs and InvITs have made it very possible for them.
Okay. So you think as an investor, more and more investor will join this type of thing after the more transparency and more clarification?
Yes, sir, because distributions were already being declared by REITs and InvITs, but if there was any unpaid or unclaimed distribution, the manner was not clear. How to, just like listed companies, they have a very detailed procedure in Companies Act and in SEBI regulations regarding the claim of their unpaid dividend amount. But it was not very clear in the REIT and InvIT regulations, and REITs and InvITs have been declaring a huge amount as distribution. It's in millions and billions. So this manner of so this will be a very comforting thing for the unit holders, that in case their amount remains unclaimed due to any reason, there is a way for them to claim that.
Okay. So thank you very much, Priyanshi.
Thank you, sir.
Now, as you are aware, the SEBI has a board meeting on 25th, and they came out with so many things. No doubt, delisting, it was the agenda item, but they have not taken up. But various item of relevance has taken place. One is the social stock exchange, which was the project. Now SEBI has reduced drastically from 1 crore to 50 lakh, and various other things has taken place. So now over to you, Anjali. Please tell us what are the major decisions SEBI board meeting has taken place and how it will impact. Over to you.
Good evening. Good evening, everyone. I hope I'm audible.
Yes.
Yeah. Thank you so much, Priyansi, for taking up the REITs and InvITs related amendments. Just like SEBI has promulgated the changes for claiming the unclaimed amounts lying in the accounts. Similarly, with regard to non-convertible securities as well, SEBI has promulgated detailed procedure as to if any of the amounts, any principal amount or dividend or interest amount is lying unclaimed, the same is needed to be transferred to the escrow accounts and then the IPF account. So regulation 61(2) of listing regulations mandate for the same. So SEBI accordingly has issued a circular by virtue of which it has issued a detailed framework. It contains 2 annexures therein. One of the annexures talks about the procedure as to how the amount is needed to be transferred to the escrow account, and then how the amount is needed to be transferred from the escrow account to the IPF accounts, and how the investors would be in a position to claim these amounts. A brief of the circulars, just like what Priyansi gave the details. Likewise, herein also the amounts are needed to be, unclaimed amounts are needed to be transferred to a escrow account, which is needed to be opened only with a scheduled bank. You cannot open it with anybody else, only a scheduled bank. Then interest in case of default at the rate of 12% is needed to be given to the said investors. Herein again, a nodal officer is to be appointed by the company, who can be either the company secretary or the CFO or the director of the listed entity. This information again is needed to be displayed on the website of the company within a period of 30 days. There has to be a search facility. Now, this is a very important point wherein if I am an investor, I don't know that any of the dividend amounts or interest amounts are accruing to me, have accrued to me, and it is lying unclaimed. So this search facility will enable me as an investor to do a PAN search, wherein I'll put in my PAN and I'll be able to understand that yes, X amount is recoverable by me from this particular company or this particular security. And the company has to prepare a formulate a policy as well, which will detail the process to be followed by the investors for claiming any of these amounts, any of these unclaimed amounts. The circular talks about the listed entities. We are not talking about companies, not just companies here. We are talking about entities, because even the bonds can be issued by various agencies, not just the companies. Municipal bodies can also issue the bonds. So listed companies, entities which are companies, have to transfer the amount to IPF account as per the provisions of Companies Act. And entities which are not falling within the purview of companies have to transfer to the IPEF account as promulgated by SEBI under the SEBI Act. The provisions will become effective from 1st March 2024. Any of the amounts which are lying with the companies for less than 7 years as on 29th February 2024, that is a day before the cutoff date, have to start computing the interest with effect from 1st March 2024. And any companies wherein the amount is lying for more than 7 years have to transfer the amounts to the IPF accounts with effect by 31st March 2024. Now, we all know that a SEBI board meeting took place last week, wherein some of the very drastic decisions, very important decisions have been taken. These decisions pertain to social stock exchanges. These decisions pertain to AIFs, REITs, all those things. So those a brief crux of the decisions which have been taken by the SEBI. First of all, with regard to social stock exchange, SEBI has been doing a lot of work ever since 2020 when it comes to social stock exchanges and listing of NPOs and non-profit organizations. The SEBI has already issued the regulations in this regard, but there were certain all the NGOs or all the non-profit organizations were finding it a bit difficult to raise money from the public because of certain limits that were set therein. So what SEBI has decided on the basis of the discussion paper it issued, on the basis of the recommendations it received from various market participants, they have reduced the minimum issue size. As per the erstwhile regulations, the minimum issue size was 1 crore rupees, which has been reduced to 50 lakhs. As a result of which, more and more NPOs or NGOs would be in a position to raise better funds from the public at large, and they would be in a position to utilize this money better towards the social cause. Then likewise, reduction of minimum application size. Earlier, this minimum application size was mandated at rupee 2 lakh per application, which everybody felt to be on a very high side. If you'll ask me as an investor, that you invest 2 lakh rupees, at least 2 lakh rupee investment you have to make in a particular in a particular public issue of NPO, of an NPO, I would find it a little higher. So according this fee, this amount has been reduced to 10,000. This reduction in application size will really benefit a lot of public retail investors as well, wherein I want to invest in a particular NGO. I know a particular NGO is doing a very good job and I want to invest in, but 2 lakh I was finding on a very high side. 10,000 is within my pocket, within my reach. I can very easily invest therein. There is a concept of social auditor is there. The concept of social auditor has been replaced with social impact assessor, so that the impact of the funds which have been raised by the NGO or the NPO can be assessed by him, which have been registered under section 1036C or 1046 of Income Tax Act. They have been brought within the purview of NPOs. So section 1036 of C of Income Tax Act covers educational institutes which are non-profit organizations, and 1046 talks about any body or authority which has been set up by a state government or a central government. So more and more agencies would be brought under the perspective of social stock exchanges, would be in a position to raise funds through the social stock exchange. Now, with regard to REITs, just like we have the concept of small and medium enterprises, SMEs, SME exchanges there. Likewise, SEBI is decided to come with S&M REITs as well, wherein small and medium REITs, as against for a normal existing REIT, the minimum asset value is rupee 500 crores. This 500 crores is proposed to be reduced to 50 crores for a small and medium REIT. This again is going to help a lot of REITs which are working in this space, and they'll be in a position to have separate schemes for owning the real estate through the SPVs as well. A lot of amendments have been, decisions have been taken with regard to AIFs as well. It has been proposed that with effect from September 2024, all the fresh AIF investments would be done only in demat form. Physical forms will not be allowed. However, if any of the investments have already been done, they may be allowed to remain in physical form, except they have given 2 categories wherein the investee company, that is the target company wherein the AIF is making the investment, has been mandated under any law to have the securities in demat form itself. This requirement is also exempted for investments held by any of the liquidation schemes of any of the AIFs. Then any schemes of AIFs whose tenure ends within 1 year, is merely 1 year from the date of issuance of necessary notification, and any of the schemes of the AIFs which are in extended tenure, which are going on in their extended tenures, those AIFs may be exempted from this requirement. AIFs have to appoint a custodian. This custodian requirement was earlier applicable for only category 3 AIFs, but now this has been extended to all the categories of AIFs. So custodian was required to be appointed by category 3 plus 1 and 2 having a corpus of more than 500 crores. Now any AIF having whatsoever corpus will be required to have a custodian. This custodian may be an associate or manager or sponsor of the AIF in compliance with the mutual fund regulations of SEBI. These were the decisions which have been taken at the board meeting. And now they have issued a consultation paper as well. A lot of work is being done at the AIF level as well. A lot of AIFs are being registered on almost a daily basis. A lot of funds are being garnered through the AIF mechanism, and AIFs are gaining a lot of traction in the Indian ecosystem. So this discussion paper, which has been issued by SEBI on 28th of November itself, targets these special situation funds. Special situation fund is a subcategory of category 1 investment AIFs, which basically focuses on acquisition of stressed loans. So Indian financial system is undergoing a lot of changes, So accordingly, this discussion paper has been brought in. This contains 6 proposals. Although we'll be covering the discussion paper, this consultation paper in detail at one of the next webinars, but just to give a brief of the proposals which have been given in the discussion paper is that the definition of stressed loans is needed to propose stressed special situation assets is needed to be redefined. Under the present laws, it says any of the loans available for acquisition. Instead of available for acquisition, it is proposed that securities of companies with stressed assets loans, it is proposed to be amended. Then investor eligibility criteria, just like in Indian under the IBC code under section 29A, here also there is a proposal for stringent due diligence on the investors. This will enhance the regulatory coherence with regard to the AIFs. Then restrictions on the investments in connected entities, expanding the definition of related parties. It is proposed to expand the definition of related parties so that the conflict of interest can be mitigated and a better transparency and integrity can be brought in. Minimum holding period. It is proposed that there should be a minimum lock-in period for all the stressed loans and restricting their transfer or sales only to the entities which have been listed by the RBI master directions. Then the next proposal is data sharing mechanisms between CE and RBI. It has been felt that all the regulators, sometimes it is felt that all the regulators are working on their own. But by virtue of this concept, it would be a better aligned system through which there will be a data sharing between SEBI and RBI, thus mandating a better transparency and regulatory oversight. And then also it is proposed for a dedicated supervisory framework so that all the activities which are being undertaken at the AIF level can be supervised in a better manner. The suggestions are to be given on the discussion paper by 27th of December 2023. So we are in the process of compiling all the suggestions and we'll be doing this webinar as well. So accordingly, we'll be giving the same to SEBI as also. Thank you from my side. These were the amendments or the discussions which have taken place at SEBI level.
Thank you very much. Thank you, Anjali, for giving details. Now tell me, social stock exchange is coming. And till now, various company has registered. You have also registered a company.
Yeah.
So what will be the impact of these changes? Do you think
so,
the query?
Sir,
Yeah.
What we realized was that stocks NGOs have a lot of clientele, but when it comes to raising of money from the public, then they are not that good at it. And if we increase the issue size to an amount of 1 crore, it becomes very difficult for them to raise those funds. So now by reducing this fund, more and more NGOs would be in a position to raise better funds. And likewise, by virtue of reducing the application size, more and more investors would be able to invest.
But do you think that suppose I am giving donation to any charitable organization, that money I will divert here?
Sir, if you'll ask me personally, if I want to say even in a very, very renowned NGO, if I want to donate, but I'm never sure whether my money is being used for genuine purpose or not. But herein, because there is a concept of social auditor, there is an independent body which will be doing the audit as well of that company. And the company is registered with a authority like SEBI or exchange. There, I'll definitely feel more inclined.
Okay, now what is the process? Suppose I want to bring out my my entity registered in social exchange or bring out issue. What is the process?
So I have to first register myself with any of the exchanges, either BSE or NSE. there are certain criteria which have been specified by SEBI, wherein 67% of my revenues during last 3 years, 67% of my expenses during last 3 years, and 67% of my customers or clientele should be with regard to social cause. I can get registered at the exchange, and then by issuance of zero coupon bonds, I can raise the funds from the public. I
Okay.
have to issue a
Yeah. Carry on.
I have to issue a placement document. Then accordingly, I can raise the funds.
Okay. So by registering, how much time stock exchanges are taking?
Your voice is breaking, sir.
How much time
Sorry?
How much time stock exchange is taking to register?
So registration by and large takes around 2 months.
Okay, but
Yeah.
how can, as a investor, as a donor, I have a confidence that if this company is registered with the stock exchange or bringing out issue, my money is safe.
So that is what I'm saying, that if giving it to a XYZ NGO versus giving it to a NGO which is registered with the exchange, which is having a social auditor, which is having social impact assessor, now is the term, who will be looking into the activities of that NGO. That gives a confidence.
Okay. So any issue is till now, any issue has come?
I think one of the IPOs has come. One company, one NGO has raised the funds. Others have registered. Almost 20-25 NGOs have been registered. Even we registered a NGO with NS.
Okay. So this will so what game changer are you finding will take place in this?
So the biggest is the satisfaction that a person gets. Again, I'm repeating myself. अगर मैं invest करती हूँ, कहीं donate करती हूँ, I never know that whether the money is being used for the genuine purpose or not. Here, I know that the money would be going for the genuine purpose, and any entity, any NGO which is getting itself registered with exchanges, or which is coming out with the issuance of ZCZPs, would surely have, it has done a basic audit, just like a listed company. A listed company, before coming out with an IPO, prepares itself thoroughly, and then only it goes to the market. Likewise, even the NGOs would be doing a proper audit of their activities.
Okay. So I will request delegates, if they have any questions, please raise. Is benefit of ATG is available for investors in social exchange, Anjali?
Presently, it's not. Unfortunately, it's not.
So what do you feel? What will happen if this is not available? What will happen?
Sir, it should be available, but presently the exchequer has not decided it in that favor.
Okay. But do you think if they allow this ATG also, it will be good?
It will be a big game changer. Yes. It will boost investment, donations.
Okay. So, Priyanshi, Nitesh, Nikita, you want to say anything additionally what you have discussed? Nitesh, you want to say anything else?
I think, sir, that's it from my side.
Okay. Nikita, you have any point in this other than this, what you have spoken? Any additional point you want to say?
So just basically, I think although they are very welcoming suggestions which have been provided by SEBI, but we still have to see what might be the practical issues being faced, because now the even with the flexibility, there are certain things which has to be very precise, and which has to be submitted to SEBI for the trading plan purpose. So that we have to we should analyze the nuances, that what could be the practical difficulties which could be faced by the designated person and the SEBI as the regulator.
Okay. Priyanshi, you have any point? Okay. So now, because today the topic is, I have received few questions which I will just ask. Is CSR is available for social exchange?
No, not present.
Okay. For what period NPO offer will be valid?
NPO offer period.
Uh,
I think it's 7 to 10 days.
so, okay. Shivam has done some poll. So I will request Shivam, there's a one poll which we have taken. Are you familiar with the newly notified significant SBA rules for LLP? The answer which is there, 56% says yes, 17% no, and 28% they want to know more. Okay. Next question, next poll, Shivam. What are your thoughts on the proposed amendment in the regulatory framework for a special situation fund aimed at facilitate the acquisition of stressed loan? 50% say supportive. Concern no one, need more information 25%, and not aware 25%. Next question. Next poll which you have done. So these polls you have done. So friends, today the topic is whatever updation was there, we have explained. And in case anybody has any query, where is to publish through exchange? What are the period of NPO after offer will be valid, and where it be published through exchange? Exchange, I think, Anjali, this is, are you giving advertisement or it is putting on the stock exchange website?
So it is put on the exchange's website.
Okay.
Publications, they are trying to restrict because
Hmm.
NGOs generally don't have those many
Much
funds availability.
Okay, okay. Nitesh, are you there?
Yes, sir.
Nitesh, somebody is asking, can you throw some light on SBO for companies?
Throw some light on.
SBO for companies, just like the way you have explained about LLP, what are the status of SBO for companies?
So actually, what we discussed, SBO in case of LLP, that all the rule actually imported from the Companies Act. So whatever be the threshold criteria, that is 10%, it is same as applicable for the company as well. Whatever be the control or having a significant influence, that is also the same in case of which we discussed today about SBO. That is same as per the Companies Act as well. All the rules as it is has been imported from the company. The threshold limit, or if you are acting in concert, or if you have a very web of structure in your corporate, then you need to check what is who is actually owning the company at the top level. If there are some individuals who are owning a company, having a majority stake in the ultimate company, then they will become a SBO for the company. So it is basically same as what we discussed today about LLP, that all has been there in the Companies Act since 2018. If still you have a doubt about it, then you can write to us or have your query discussed, or whatever be the queries regarding any specific question, that we will happy to actually clarify to you.
Yes, Nitesh. So friends, now because we have covered all the aspects of this particular month, and we confined to the topic which are there. So before closing this session, I just want to announce again that next webinar is very, very important. That is 155th webinar of corporate professional. As you are aware that every week we are doing, and this and in the webinar we are also covering the consultative paper. And our approach is this: you should be proactive, not the reactive. Okay, when the law is there and then you are making a mean make and identify the problems, it is better that you should tell today. So when the lawmaker can identify. And I will tell you, the lawmaker has also changed their attitude. It is not earlier the law they have published, they have made the law and then you follow and then you face problem and then they are changing. Now the consultative paper purpose is that they are coming out, they are telling that we are coming out with this law or we are modifying this particular aspects in the law. If you think something is missing out, please tell us. So this program we are doing, Mr. Sundaresan, B.S. Sundaresan, who is the Executive Director of SEBI, will be the chief guest. And Ananya Kumar Das, Chief General Manager, SEBI, and Mr. Vijayan will be our panelists. And from industry, from stock exchange side, Avishkar Nayak and Gopal Krishan, we have requested them. They will, and we have requested them to join. Ajay Agrawal from HDFC Bank, Geetika from Hindalco, Nehal Shah from CARE, and Savitri Parekh from Reliance will discuss. And Mohini, she was member of this trading plan committee, so she will also discuss this issue. And I hope that whatever issues, and we have come out very interesting discussion paper which we have shared with all the speakers, and we are coming out with the FAQ of the trading plan. We are coming out with the issues of the trading plan. What are the issues which has to be clarified? Any doubt is there? So the purpose is with SEBI and stock exchange and industry that from our side, whatever law is coming, it should be perfect. It should not have a various inferiority. So implementation issue, whatever you can visualize today, you please try to remove. And that is the purpose of these types of program which we are doing. So I hope that with these experienced panelists, we will definitely bring out something great, something good for the industry, something good for the professionals, and something good for the corporates. So with these things, see you on 8th, 4 o'clock on Friday. Until then, goodbye to all, and we will meet again.
Okay, bye. Thank you.
Thank you, sir.